Good evening, everyone. Welcome to the Innovation Hub. We're also right across the road, host of the CSIR, which is the largest research institute in Africa. And so that perhaps brings us to the topic this evening that we are discussing, which is the role of intellectual property. And it's our aim that the time that we're going to spend this evening together will help us to demystify this particular subject. It's also our hope that by the time you walk out of this auditorium this evening, you'll be much more clearer in terms of the role of intellectual property, the various parts of intellectual property, and some of the challenges in terms of working with intellectual property.
I think, and what's most important is that everybody must recognize that what we do when we do business, intellectual property is part of that, whether we call it that or not. In terms of protecting intellectual property, first of all, what you need to do is you need to identify it. And whether it's know-how that you need to keep secret, or whether it's a patent that you want to file, or a design, or a trademark, or something you want to franchise, all of those are categories of intellectual property law. I would say it is protecting that core of your business that's giving you the competitive edge against the competition.
So a patent would be, if we look at this little bottle here, here we would protect the basic concept. And I think we all more or less know what a patent is all about. It's about protecting a concept, an underlying concept, not an appearance, but what this thing does. And that's where designs come into play, because that's all about what it looks like. There's a lot of bottles that fulfill the same function, but only some has aesthetic appeal. And then just one last thing, as in life, nothing is ever absolute. Sometimes, form truly follows function, and that's where there's also a functional design. And that's a design, but in that case, it's not based on the appeal of the article, but it's based on the function that it will have to fulfill.
You can protect a system which uses a source code through a patent. However, the source code can be protected through copyright. Other forms of copyrighted works that can be protected is, if you look at this bottle, the write-up on this bottle can be protected by copyright. And the only way that one is able to protect any material through copyright if that copyrighted material is actually put onto a physical. In a physical form. For example, you cannot protect an idea. That idea or that source code should be put on a document for it to be protected through copyright. Copyright is a non-registrable intellectual property. So there's no need for you to actually register your copyright. It subsists automatically.
Trademark is meant to differentiate your product from that of your competitor. It's very important that every product that you have, that you consider essential for your company and for your business model, you protect it by way of trademarks.
There's registered trademarks, and you also get unregistered trademarks. So in the registered trademark category, you have a TM and you also have an R. So the difference between that is that if you have a TM, that means it's an application for a trademark that's still pending. Once it has been registered, then you can put a R sign around it to show that it's a registered trademark. The other forms of trademarks is whereby you acquire the trademark by use. But the important thing is always try to register your trademark, because then you can prove that I own this trademark, I've registered it.
A patent is only valid for 20 years, but your business might outlast that patent. So it's quite important that in parallel with building your patent, you also should develop a trademark strategy so that people get to know your brand, not only through what you've patented, but also through the reputation that you've made.
Trademarks exist indefinitely, All you have to do is to make sure that you renew it every 10 years, right?
Yes.
Otherwise it lapses. When we have a patent, it lapses and people may forget you, but when you have a trademark, your product is still out there and your trademark is still out there. That's why it's also important to focus on trademarks.
What you'll have to do is that at the end of the document, you'll have to put your C and then the year as well as the owner of the copyright. So that will actually provide us with an indication of who owns that copyright and when was it developed.
Design, the principles is very much similar to patent law, although for aesthetic design the time is 15 years, and for functional design it's a 10-year period, and then it's nothing you can do to extend, or that's a finite period. Where in patents and designs you do have these time constraints. After a certain period it becomes open to the public domain. I think that's one of the big advantages of know-how, is because that's something that's potentially perpetual if you manage to keep it confidential.
Patents, as with most IP rights, are territorial. So, I mean, a lot of people, they go and file a provisional patent application. From there, they file a PCT application, and from there, they assume they have an international patent. So it's a very important thing to remember as well, to say, not everything that you think is an invention will eventually get granted as a patent, and there's no such thing as a worldwide patent.
If it's a product that needs development, don't reinvent the wheel. Don't start developing the product all over again. The best way to do it is to be a supplier. If you are an entrepreneur, go to them, let them manufacture, and be the supplier of that product. And if you want to go into other countries, you'll have to look at if they have patent application in those countries, what their intentions are. So always look out for the development of that patent application.
Your invention is supposed to be novel. By novelty, it means that your invention should not have been done anywhere in the world.
But well, a PCT application is an international application filed through a UN agency called WIPO. And it allows you to, it extends the time period for you to be able to file national patent applications.
A lot of people think once they have a patent that's going to magically open doors. And the reality is that is just one small step to the whole path of success. And that's where your commercialization strategy comes into play. The business should drive the process. You can't just rely on the new technology to think it's going to be successful. It's just one small cog in a whole big machine.
There's basically two things that you can do with it. Selling means you will be assigning it to somebody else, and you would transfer all your rights to that other party, which means that it's a one-step process, and you will have to be paid for whatever you are transferring to that other party. The other model is that you retain your rights and you would license it to that party. It's like renting out your car or anything else, and they would be paying you a royalty income as they use it.
If you have a know-how that can get your processes to be more efficient than your competitor, which is not necessarily protected by patent, but you are able in a position to license that know-how, it also plays a very important role in making the decision and from a funding perspective.
Yeah, I think probably the most IP disputes is not about infringement, it's probably about ownership, because that's something that's often overlooked. And it's also something that usually only becomes a problem when the product is starting to make money. Specifically with copyright, if there's no agreement in writing, the copyright will vest in the creator of the work. There's no implied assignment that can take place, even if I pay him to do the work. I may get an implied license, a perpetual license, but the actual ownership still resides in the author.
It's very important that when you enter into a contract with your employee, you make sure that you specify that you as the employer, you will have the rights to specific inventions that are made during the scope and course of employment. So it's very important that during the contracting, you specify what exactly am I employed to do, so that we don't have dispute when I discover something that is very useful.
Regulation 9 says that if you want to export IP, you are supposed to obtain exchange control approval. So if you want to sell your IP to some foreign guys, you need to obtain exchange control approval. If your license is royalty free, you definitely need to obtain exchange control approval. As well as if you and the US guy, you are somehow connected, so your the transaction is not at an arm's length basis, then you also need to obtain exchange control approval.
But one needs, I think just one needs, you do not need to take a stance to say I'm against patents or I'm for patents. The question is really, whatever your business is doing, you must do what's right for the business.
If you file a patent, you have to disclose what your invention is. And you may not necessarily want to do that. So again, it comes down to if you increase your efficiency to 97 by adjusting the temperature from 200 degrees to 300 degrees, you might not want to put that in a patent, because once you do that, then everybody has access to that information. So you want to keep that as know-how and possibly a trade secret. The downside to that is that if you keep it as know-how, you might disclose it to somebody else and they have access to that information. If you got no recourse. Whereas if you're filing a patent in a specific territory and somebody is infringing on your patent, then you've got recourse against that person.
If you manage to keep it confidential, obviously it can be very valuable. It can potentially be perpetual. People recognize the value of knowing how to do things and not only what you do.
So if you've got an option to go for patent, then you can go for patent.
If you cannot be able to police it, then perhaps keep it as a trade secret. But if they came up with the process independently of you, then they can do whatever they wish to. Quite often, the commercialization of intellectual property requires know-how, which is owned, or is basically that know-how is around a researcher. So it's quite important also when you are a recipient of technology, when you are in licensing, to make sure that you identify the critical people that will form part of the technology transfer.
The whole thing about costing, one must be very, very clear on this, and we were discussing it beforehand. It's always a problem. The fact of the matter is you are spending a heck of a lot of money on developing your business, obtaining software, paying salaries, paying rent. So cost is relevant, but one must also not be penny wise, pound foolish when it comes to costing. So very often you file a patent and that patent would never even be litigated on.
Before you can think about litigation, you really need to think about it very carefully.
And when it gets to litigation, it's also a decision in terms of, am I going to litigate or not? Is it worthwhile? Is there real infringement? Is my patent valid?
So we understand that patenting is expensive. Whatever you want to patent, it must be something novel. What we also require is that you must have actually made some investment into that technology. The fact that you've put in money to file a proper provisional patent application, for us it means that you are willing to take the patent forward.
So it's not like SARS actually sits down and say, for example, if you have spent R1 million on development of an IP, then you're supposed to be getting 500,000 for that amount. You have to convince them, and if they are convinced that you will be obtaining a reasonable amount, then they will provide you with approval.
What one needs to be also working out on is, what is the value of the business without the IP? And what value add does the IP add on to the business?
If you come up with an invention or a know-how or intellectual property, if that intellectual property was developed within the course and scope of your employment, that intellectual property is actually owned by Sasol. So if the know-how falls within the course and scope of your employment, even if, that's one thing that I also want to mention, even if there's no contract between yourself and Sasol, it doesn't matter. Common law will be applicable, because common law says that as long as that IP was developed within the course and scope of your employment, it shall be owned by Sasol.
The patent application, it's expensive. The sad part about that is you have to file it before you disclose it. So before you know if it's going to be successful, whether technically or commercially, you have to file that patent. I mean, just the renewals fees per year quickly amounts to millions. So that is, I think it's a reality, but it's one must see the value also that you get for that.
If you have a patent filed, and somebody is infringing on your patent, we always think now about R500,000 of instituting litigation. Now, the irony of the matter is the guy on the receiving end of that letter of yours, he has to take that letter and he also has to go and see a patent attorney.
The only time where one will know whether it was worth it, the money that you have spent was worth it, is when there is litigation taking place. I think the Reserve Bank did not actually foresee the dangers of including intellectual property within capital, because now the regulation says that capital includes intellectual property.
What stage would you want to get from funding the recipient? Do you want to get equity? Do you want to get royalties? The other things that you need to consider is who's gonna take care of the cost of filing.
You have a patent, but in order to commercialize it, you need another patent. Somebody else's patent. Then it's a matter of a licensing arrangement. So a voluntary license is the first option. In the case that they refuse voluntary license, there's provision for compulsory licensing.
I think the biggest thing to patenting is the cost. People are very wary of the cost, and also they don't see the perceived value of patenting. Things like the IPR Act, the IP Fund are there to encourage people to actively protect their invention, but not also only to protect, but also to commercialize.
If you're enforcing a patent, it costs a lot of money. But if you have a design registration as well for the same article, you don't need to necessarily use them. You can use just any attorney, and it's much cheaper, to be able to enforce a design registration. You don't have as much evidence to lead. And I think what you're seeing in terms of intellectual property is becoming a currency. I think the issue of infringement, one of the things perhaps to consider is look at the size of the market. So if there's an infringement, what is that market that infringer is taking away from you? And what is the cost of enforcement? And as you develop the portfolio, go to the patent attorneys and get help. With that, let me perhaps thank my panelists. If you can give them a round of applause.
Let me thank you first as the audience for coming through. You are the reason why we do what we do.